In the weeks following Donald Trump's recent interventions in federal prosecutions and his public pressure on the Department of Justice, something unusual happened in foreign capitals. Intelligence analysts in Beijing, Moscow, London, and Brussels began circulating internal assessments. But these weren't about American domestic politics. They were evaluating the stability of U.S. legal institutions as a geopolitical variable. Here's the paradox that has their attention. Trump may be acting within his constitutional authority as chief executive. Yet those very actions are triggering what some strategists are calling a hidden justice crisis, one that extends far beyond partisan battles in Washington. To understand why, you need to recognize something most analysis overlooks. America's justice system has always operated on two foundations. The first is formal legal authority, what the Constitution and statutes explicitly permit. The second is informal institutional norms, unwritten rules about what presidents should avoid even when they legally can act. For decades, the second foundation mattered more than the first for maintaining credibility, both domestically and internationally. What appears to be a political controversy about investigations is actually a stress test of mechanisms that underpin America's global influence. Sanctions enforcement, extradition treaties, anti-corruption cooperation. The soft power that comes from being seen as a nation governed by law rather than political whim. Both Trump supporters and critics may be missing the deeper dimension. This isn't primarily about whether specific prosecutions proceed or particular individuals face charges. It's about whether the institutional architecture that makes American legal power credible on the world stage can survive when those informal norms are repeatedly violated. What most people miss is that America's ability to impose sanctions, secure extraditions, and lead anti-corruption efforts depends less on military power than on a specific kind of institutional credibility. And that credibility just became questionable. The triggering events are both public and partially obscured. What we know with certainty: Trump has made repeated public statements about ongoing federal investigations, specifically those involving his allies and former associates. He has openly criticized prosecutors handling cases he views as politically motivated. He has discussed, in some instances on social media, in others through reported conversations, the possibility of firing officials overseeing sensitive inquiries or issuing pardons before convictions are secured. What credible reporting indicates, though not yet fully confirmed, direct pressure on the Attorney General to influence prosecutorial decisions in specific cases. Conversations about replacing career prosecutors with political appointees in investigations touching his administration. Attempts to shape the timeline and scope of inquiries that could affect his political future. What remains alleged: explicit orders to halt prosecutions or explicit promises of pardons in exchange for silence. The institutional response has been swift but fragmented. Former Department of Justice officials, including those who served under both Republican and Democratic administrations, have issued public warnings about the erosion of prosecutorial independence. Federal judges have made rare public statements about the integrity of the judicial process. Congressional oversight committees have launched inquiries, though these efforts divide along predictable partisan lines. And quietly, in diplomatic cables and intelligence assessments, foreign governments have begun documenting these developments as indicators of institutional stress. This situation differs fundamentally from routine executive-judicial friction. Presidential administrations regularly clash with courts over policy, immigration enforcement, environmental regulations, executive orders. Those are disagreements about the law's application. What's happening now involves the perceived use of prosecutorial power for personal political protection and potential retaliation against perceived enemies. The actors involved highlight the peculiarity of the American system. The Department of Justice sits within the executive branch. The Attorney General serves at the President's pleasure. Federal prosecutors are executive employees. Yet, the entire structure has historically operated under the assumption of insulation from direct political interference in individual criminal cases. It's a norm, not a constitutional mandate. The federal judiciary remains independent, but can only respond when cases reach the courts. Congress has oversight authority, but limited direct operational control. The timeline shows escalation rather than isolated incidents. Each action builds on the previous, testing boundaries, measuring institutional resistance. The deeper framing matters. This is not simply Trump versus his enemies. It is a stress test of institutional mechanisms that have allowed the United States to claim rule of law superiority over authoritarian competitors for decades, a claim that underpins sanctions regimes, alliance structures, and the entire architecture of international legal cooperation. The immediate controversy is visible, but the hidden crisis lies in what these actions reveal about the actual constraints, or lack thereof, on executive interference in justice systems that the entire international order assumes are politically independent. The modern expectation of Department of Justice independence isn't found in the Constitution. It emerged from a specific historical trauma, Watergate. On October 20, 1973, President Richard Nixon ordered the firing of Special Prosecutor Archibald Cox. Attorney General Elliot Richardson resigned rather than comply. Deputy Attorney General William Ruckelshaus also refused and was dismissed. The Saturday Night Massacre didn't violate any statute. It violated something more important, the emerging norm that presidents shouldn't manipulate criminal investigations touching themselves. The reforms that followed established modern expectations: independent counsels, career prosecutor protections, and an unwritten but powerful convention that the DOJ operates with substantial insulation from White House political direction on individual cases. This wasn't constitutional restructuring. It was institutional culture. During the Cold War, this culture became strategically valuable. America could credibly distinguish itself from the Soviet Union not just through economic prosperity or military strength, but through demonstrable rule of law. Soviet justice was visibly arbitrary, subordinated to political needs. American justice, for all its flaws, operated within institutional constraints that even presidents respected. That distinction mattered for alliance building, for moral authority in the developing world, and for the ideological competition that ultimately shaped the century's outcome. That credibility enabled something remarkable: the expansion of American legal extraterritoriality on an unprecedented scale. Sanctions enforcement requires foreign banks and corporations to comply with U.S. law even when their governments disagree. Extradition treaties assume American courts will provide fair trials to foreign nationals. Mutual legal assistance agreements presume prosecutorial decisions follow evidence rather than political direction. The Foreign Corrupt Practices Act, initially resisted by other nations, was gradually adopted as an international standard, partly because American enforcement appeared consistent and rule-based. Allies accepted this overreach because they trusted the underlying process. European banks paid billions in penalties for sanctions violations. Foreign executives faced extradition on American charges. Nations cooperated with American investigators probing corruption on their own soil. This cooperation was never purely voluntary. It was coerced by American economic and diplomatic power. But it was tolerated because the coercion appeared to follow rules. Historical precedents demonstrate how the system contained internal tensions. Iran-Contra saw a special prosecutor investigating officials of a sitting president. Whitewater and the Lewinsky investigations subjected a president to prolonged legal scrutiny. Post 9/11, tensions between security imperatives and judicial oversight produced genuine constitutional conflicts. In each case, institutional resistance, from career prosecutors, from courts, from congressional oversight, contained the pressure without destroying the underlying credibility. Adversaries watched closely and exploited every deviation. Russia's information operations perfected whataboutism, using American legal controversies to deflect criticism of Moscow's own practices. China consistently points to American inconsistencies when Western governments criticize its treatment of dissidents or its opaque legal system. The message: your rules aren't really rules, they're just power dressed up as principle. The Obama and early Trump years saw escalating tensions around FBI directors, special counsels, and the norm that presidents don't publicly discuss ongoing investigations. Each violation was contained until now, when the containment mechanism itself has become the target. History shows that America's ability to enforce its will through law rather than force depends on a perception of consistency, and perceptions, once damaged, are extraordinarily difficult to restore. American legal power operates through a network effect that most citizens never see. When the Treasury Department designates an Iranian entity for sanctions, European banks freeze accounts not because they fear American military action, but because they trust the underlying process is legitimate. When American prosecutors indict a Chinese executive for fraud, Canadian authorities arrest them not because they must, but because they believe the charges follow evidence rather than political direction. When the FBI shares intelligence with British counterparts, MI6 acts on it partly because trust has been built over decades of consistent, rule-bound cooperation. This network is the hidden infrastructure of American global influence, and it depends entirely on perception. Consider sanctions enforcement. European financial institutions face a choice thousands of times daily: comply with American sanctions that may conflict with their commercial interests, or accept the risk of massive penalties. The compliance calculation isn't just about penalty amounts. It's about predictability. Banks accept the cost of following American rules because they believe those rules will be enforced consistently. If enforcement appears politicized, if it seems certain administrations pursue certain targets while ignoring others, the calculus fundamentally shifts. Banks begin hedging. They develop workarounds. They quietly build capacity to operate outside American-controlled financial systems. Intelligence sharing operates on similar logic. The Five Eyes Alliance, the United States, United Kingdom, Canada, Australia, and New Zealand, shares extraordinarily sensitive information based on mutual trust developed over generations. Part of that trust involves confidence that intelligence won't be misused for domestic political purposes. When allied services provide information about suspected terrorists, foreign agents, or organized criminals, they assume it will inform legitimate investigations, not political persecutions. Perception of politicized justice creates hesitation, not dramatic withdrawal, but subtle recalibration about what to share and when. Extradition dynamics reveal the pattern most clearly. When American prosecutors request the extradition of a suspect from Germany or France, allied courts don't simply comply. They evaluate whether the accused will receive a fair trial, whether the charges appear legitimate, whether the process respects human rights standards. This evaluation has historically favored American requests because U.S. courts have credibility. But that credibility isn't automatic. It's earned through consistent institutional behavior, and it can be lost through consistent institutional deviation. The China dimension makes this particularly consequential. Beijing has argued for years that Western rule of law rhetoric is performative hypocrisy, that democratic legal systems ultimately serve political power just as Chinese courts do, only with better public relations. American institutional dysfunction validates this narrative in ways no Chinese propaganda campaign could achieve independently. When Chinese diplomats respond to Western criticism of Beijing's legal practices, they now have American examples to cite. When developing nations choose between American and Chinese models for their own institutional development, the American model becomes harder to defend. Russia's strategy is different but complementary. Moscow doesn't try to convince the world that Russian justice is superior. It works to convince the world that no justice is truly independent, that all legal systems ultimately serve power, so criticism of Russian practices is naive or hypocritical. This strategy succeeds when democracies undermine themselves. Every American norm violation gets amplified through Russian information operations, reaching audiences in the global South already skeptical of Western moral claims. Alliance management becomes progressively more difficult. Consider Germany's position. German prosecutors regularly cooperate with American investigations. German banks pay American penalties. German intelligence shares information with American counterparts. This cooperation is politically controversial domestically. German officials defend it by arguing that American justice is reliable, rule-based, and worth supporting even when specific decisions seem harsh. That defense becomes untenable when the American system appears politicized. Officials in Berlin, Paris, Tokyo and Canberra must increasingly explain to skeptical domestic audiences why cooperation with a potentially compromised American justice system serves their national interests. The precedent danger extends beyond current controversies. If Trump can interfere with investigations touching himself and his allies without meaningful institutional consequences, that authority doesn't disappear when he leaves office. It transfers to every subsequent president, Republican or Democratic. Allies must assume that any cooperation with American investigations could be reversed for political reasons by future administrations. Long-term partnerships depend on institutional predictability that transcends individual leaders. The broader competition between governance models hinges on which system appears more stable and predictable. Chinese leaders argue their system provides consistency because political direction is explicit and unified. Democratic systems traditionally counter that their institutional constraints provide different but superior stability, decisions based on rules rather than the whims of individual leaders. Institutional crisis in the world's leading democracy shifts that comparative advantage. The hidden crisis isn't that Trump might succeed in protecting allies or punishing enemies. It's that the attempt itself erodes the institutional credibility that has been America's most durable strategic advantage. The immediate sanctions implications are already visible. Ongoing enforcement against Russia, Iran, North Korea, and other targets becomes measurably more difficult when the prosecutorial apparatus appears politicized. Compliance depends on the belief that violations will be prosecuted based on evidence, not political convenience. When Iranian oil traders assess whether to risk sanctioned transactions, they now calculate not just enforcement probability, but political predictability. That calculation increasingly favors risk-taking. European alliance dynamics reveal cascading pressures. France's long-standing push for strategic autonomy has struggled against European reluctance to duplicate existing American-led systems. Building alternatives to SWIFT, developing independent payment mechanisms, creating European-controlled financial infrastructure. These projects have moved slowly because most European governments preferred cooperation over expensive duplication. American institutional instability shifts that calculation. Suddenly, the cost of building parallel systems seems worth paying, not because Europeans want confrontation with Washington, but because they need insurance against unpredictability. The China opportunity is substantial and growing. Beijing has consistently argued that its governance model, while not democratic, provides stability and predictability that chaotic American democracy cannot match. This argument has traditionally struggled in international forums because American institutions demonstrably functioned even through political turbulence. That demonstration is weakening. Developing nations choosing between American and Chinese models for infrastructure, technology standards, or legal frameworks increasingly hear a Chinese pitch that sounds credible: predictable authoritarianism versus unpredictable democracy. The corruption dimension is particularly consequential. International anti-corruption efforts depend heavily on American enforcement of laws like the Foreign Corrupt Practices Act and the willingness of American prosecutors to pursue cases involving foreign officials. Reform-minded prosecutors in developing nations, civil society organizations fighting kleptocracy, and international bodies coordinating anti-corruption efforts all rely on American leadership. If that system appears selective and politically motivated, kleptocrats gain confidence and reformers lose crucial support. Intelligence community implications extend beyond the Five Eyes framework. Allied services sharing sensitive information may impose additional restrictions, delay transfers, or reduce the sensitivity of shared material if they fear political misuse. This affects counterterrorism cooperation, counterintelligence operations, and strategic early warning systems. The impact isn't dramatic withdrawal, but gradual erosion, less information shared, more caveats attached, longer verification processes. International business impacts flow through capital allocation decisions. Multinational corporations base long-term investments on predictability. When executives evaluate whether to build supply chains through American jurisdictions, comply with American standards, or align with American technology platforms, legal predictability weighs heavily. Political interference in justice creates uncertainty that affects everything from bond markets to compliance investments to strategic partnerships. Companies increasingly consider hedging strategies that would have seemed unnecessary a decade ago. The human rights and democracy promotion dimension may suffer most immediately. America's ability to criticize authoritarian practices in Belarus, Venezuela, Myanmar, or elsewhere depends on perceived moral authority. Domestic institutional dysfunction provides these regimes with deflection material that requires no fabrication. When Washington criticizes political prosecutions abroad, targeted governments now respond with references to American controversies that are difficult to dismiss. The precedent for democratic allies is particularly troubling. Backsliding democracies like Poland, Hungary, India, and others have watched American institutional debates carefully. When their own governments face criticism for undermining judicial independence, they now have American examples to cite as normal democratic practice. The long-term damage is the hardest to reverse. Institutional norms are easier to break than rebuild. Even if future administrations attempt to restore independence, the precedent exists and trust must be re-earned. These aren't theoretical future risks, they're consequences already unfolding in diplomatic cables, corporate boardrooms, and the strategic calculations of allies and adversaries. Section 6. What happens next? For plausible scenarios, frame the range of possible outcomes. Scenario 1. Institutional resistance prevails. Courts push back against executive overreach. Career DOJ officials maintain independence despite political pressure. Congressional oversight, including from some Republicans concerned about long-term precedent, creates meaningful constraints. Public pressure reinforces institutional resistance. Trump faces limitations similar to previous presidents who tested boundaries. The system bends but doesn't break. International partners observe American institutions weathering the stress test and, over time, confidence potentially strengthens because the system demonstrated resilience under genuine pressure. Indicators to watch: successful judicial rulings against executive interference, bipartisan congressional inquiries producing substantive findings, career prosecutors continuing sensitive investigations, limited actual interference in specific cases despite public rhetoric. Scenario 2. Gradual norm erosion. No single dramatic constitutional crisis emerges. Instead, small violations accumulate steadily. Politicization increases incrementally. A prosecutor reassigned here, an investigation quietly narrowed there, a pardon issued at politically convenient moments. Each individual action seems manageable. Their cumulative effect is substantial. International partners adjust by gradually reducing dependence on American systems. American legal power remains significant but measurably diminished. Precedents accumulate for future presidents of both parties. Indicators: selective prosecution patterns emerging over time, career official departures increasing, foreign compliance with American legal demands declining at the margins. European payment platforms and regional legal frameworks developing new capabilities. Scenario 3. Acute crisis and partial recovery. A specific triggering event forces confrontation. Perhaps mass firing of prosecutors overseeing sensitive investigations. Perhaps pardons for close associates before trial. Perhaps explicit, documented interference in an ongoing case. The event provokes major institutional response, congressional hearings, judicial intervention, possibly impeachment discussions. Market disruption follows. Allied governments issue rare public statements of concern. The confrontation forces resolution, either through political consequences for the president or through institutional reforms. The system recovers, but with permanent scars and heightened awareness of vulnerability. Indicators: Saturday Night Massacre-style dramatic event, unprecedented judicial statements, allied criticism becoming public rather than diplomatic, followed by measurable institutional correction. Scenario 4. Systemic breakdown. Norms collapse entirely. The DOJ becomes a visibly politicized instrument. Rule of law credibility is destroyed both domestically and internationally. Sanctions enforcement degrades severely as compliance calculations shift. Allies accelerate decoupling from American-led systems. China and other authoritarian competitors gain strategic advantage. American power fundamentally reorients from law-based influence to purely transactional relationships. Indicators: mass resignations of career officials, judicial rulings openly defied by executive branch, congressional oversight rendered irrelevant, allied nations publicly criticizing American institutions. Dramatic increases in sanctions violations, intelligence sharing curtailed formally rather than quietly. The key variables determining which scenario unfolds are identifiable. How strongly do institutions resist? Do Republican politicians defend institutional norms when they conflict with immediate party interests? Does public pressure translate into meaningful political consequences? What specific triggering events occur? How intensely do international partners respond? Different actors are watching different indicators. Allied governments monitor compliance rates and institutional stability signals. Adversaries test boundaries to see what responses emerge. Businesses adjust compliance investments based on predictability assessments. Career officials make daily decisions about whether to resist quietly, resign publicly, or accommodate reluctantly. Historical patterns suggest gradual erosion is often the most likely outcome. Dramatic crises tend to be visible and therefore actionable. Quiet decay is harder to detect and easier to normalize. The ultimate outcome won't be determined by Trump alone, but by whether institutions, politicians, and citizens recognize that what's at stake extends far beyond partisan politics to the foundations of American power. Return to the opening question. How did Trump trigger a hidden crisis? The answer is now clear. The crisis was always there, hidden in the gap between formal legal authority and informal institutional norms, between what presidents could do constitutionally and what they had historically chosen to avoid institutionally. Trump didn't create this vulnerability. He exposed it by doing what previous presidents had the legal power to do but chose not to attempt, revealing that the constraints holding the system together were based on norms rather than enforceable rules. The strategic lesson matters beyond current politics. In geopolitics, we're accustomed to analyzing military capabilities, economic leverage, and diplomatic relationships. We often overlook that institutional credibility itself is a form of power, perhaps America's most distinctive and durable advantage. The United States wasn't always the world's largest economy throughout its period of dominance. It wasn't always the largest military. But it has been the most institutionally credible major power, the one whose legal system others grudgingly trusted even when disagreeing with specific decisions. That credibility enabled extraordinary legal extraterritoriality, sanctions that reshape global commerce, extradition treaties that reach across borders, anti-corruption frameworks that other nations adopted. All of it depended on perception of consistency. The paradox is bitter. The same constitutional flexibility and democratic dynamism that make America adaptable also create vulnerabilities that more rigid authoritarian systems avoid. China's legal system may be unjust, but its political subordination is explicit rather than hypocritical. We don't yet know which scenario will unfold, whether institutions will hold, whether norms can be restored. But we can already observe strategic consequences beginning: hesitation in allied capitals, opportunity in authoritarian regimes, uncertainty in corporate compliance departments worldwide. Future historians may identify this period not by who won which election, but by whether the world's leading democracy proved that rule of law and political accountability can coexist, or whether it demonstrated that legal independence is a luxury democracies abandon under pressure. The crisis America didn't see coming wasn't Trump's actions themselves, it was the revelation that the institutional foundations of American power were always more fragile than the world believed.